Hi, I'm attorney Jeremy Huss. What is the admin per se implied consent law relating to DUI cases in Arizona? Admin per se and implied consent are Department of Motor Vehicle ramifications relating to DUI license suspension, but both are two different things. Let's take the next few minutes to discuss these two Department of Motor Vehicle license ramifications for a DUI. Admin per se is a legal term used in Arizona to refer to the automatic suspension of a person's driver's license for a certain period of time if the person is driving and their blood alcohol content is over 0.08%. Under Arizona law, if a driver is arrested for DUI and their blood alcohol content is above the legal limit of 0.08%, the police officer will confiscate the person's driver's license. However, the officer will also issue a temporary driving permit that is in effect for 15 days, unless the driver requests a Department of Motor Vehicle hearing within that 15 days. If the Department of Motor Vehicle hearing is timely requested within that 15-day window, a stay is placed on the suspension until the time of the administrative hearing. Any person arrested while driving with a blood alcohol content of 0.08% or greater faces a 90-day driver's license suspension, or 1 year for repeat offenders. The purpose of the admin per se law is to provide an immediate penalty for DUI offenders, regardless of whether they are ultimately found guilty in court. It also serves as a deterrent against DUIs as drivers face an automatic driver's license suspension, even before their criminal case is resolved. Well, the admin per se is the automatic suspension of a person's license if they are driving a vehicle with a blood alcohol content greater than 0.08%. The implied consent refers to something a little bit different. In Arizona, implied consent refers to the legal concept that all drivers on public roads have implicitly given their consent to chemical testing of their blood, breath, or urine if the person is suspected of DUI. Simply put, implied consent is considered an agreement that drivers make when they apply for and accept a driver's license in Arizona. By accepting a driver's license, a driver agrees to submit to chemical testing if they are pulled over on suspicion of DUI. So if a police officer has reasonable grounds to believe a driver is under the influence of alcohol or drugs, the officer can request that the driver take one or more chemical tests to determine blood alcohol content. The officer will choose which chemical test is to be administered, and an officer may choose blood, breath, or urine tests. It is important to note refusal to submit to the chemical test will result in a 1-year suspension of the person's driving privileges. This is true even if the person is not ultimately convicted of the DUI. It is important to note that a person has a right to an administrative hearing with the Department of Motor Vehicle. This must be requested within 15 days from the date the police officer serves the admin per se implied consent suspension. So if the DUI occurs on January 1st, a person has until January 16th to file the administrative request for a Department of Motor Vehicle hearing to stay the suspension on the license. This is a hard rule by the Department of Motor Vehicle. If the driver does not request an administrative hearing timely within the 15 days, their license suspension will automatically take effect on the 15th day. An Arizona Department of Motor Vehicle administrative hearing is a legal proceeding that allows a driver to challenge the suspension of their driver's license following a DUI arrest. The Department of Motor Vehicle administrative hearing may be requested whether a person submits to the chemical test or refuses the test. Again, it is important to note this hearing must be requested within the 15-day window. At the DMV administrative hearing, the administrative law judge will consider evidence presented by the driver and by the Department of Transportation. The evidence presented by the Department of Transportation will come from the arresting officer. A driver has a right to ask the officer questions under oath, or a driver may retain counsel to conduct the examination during the hearing. The administrative law judge will consider the evidence presented and determine whether the Department of Transportation met its burden, which is by preponderance of the evidence. The only thing that must be proven for the suspension to go into effect are the person was driving and the person had a blood alcohol content above a 0.08% or an illegal drug in their system, or the driver refused the chemical test. If a person is found to have been driving with a blood alcohol content above a 0.08%, the person will lose their driver's license for a period of 90 days. If the person has a prior refusal or a prior DUI conviction within the past 84 months, the license suspension will be for a period of 2 years. As harshly, if a person is found to have refused to submit to a chemical test, the person's driver's license will be suspended for 1 year, regardless of whether they are ultimately found guilty of DUI. It is important for a person to know their rights during a DUI investigation. Knowing the rules for chemical testing could be the difference between a person losing driving privileges for much longer periods of time. If you have been subjected to a chemical test in Arizona, it is important to consult with and retain a competent criminal defense attorney, like the attorneys at Huss Law. Call us today for a free consultation.